Mr. Jatin Popat is the founder and CEO of Will Jini. He's a lawyer by qualification and has over 25 years experience in the legal and succession planning space. Over to Amitabh and Jatin.
But really, we see that there's a growing need for wills and trusts and putting this in place because life has certainly become a lot more uncertain. Post-COVID, one has realized that things are fragile. And we have also had a number of that we have seen the amount of unclaimed assets. And if I look just at that metric, the amount of unclaimed assets which are available in every financial instrument is quite significant, which is lying with the government and nobody's claiming it. While having PANs, nominees, etc., helps to some extent, having a structured way of dealing with them ensures that at least whatever efforts which we have put in does not go waste or does not go lie unclaimed, because that's the last thing which you would want.
So the question is in terms of wills and trusts. How do you? So the question which you were answering was in terms of what are wills, and if you could just expand that into wills and trusts and the applicability, where do they come in?
Sure. Yeah. So will is a basic document. Will is something which everyone in the world, they would like to write it for whatever they earn in life and how they want to give it. So it's a basic document of accumulating all your information or the wealth and how you want to distribute to your family or whoever you want to give it. So will is something, a wish document, which you can change any number of times during the lifetime. So as on that, if I want to write a will, I will say that who are my family, what is my assets, whom I want to give today, something happens to me tomorrow. So that's the basic document, which is like a declaration by yourself that how you want to give your wealth, because it's your wealth, it's your wishes, which your family, your government, everybody would like to understand your wishes, how you want to distribute. The transfer part is something different. It's a law process in all the countries differently. In India also, there is a different process on that. So will is something where you are putting everything on your wealth for the transmission. Now, the family trust is something where it is like creating a small bank locker or a small private limited company or something where you are parking some of your asset into the trust, where that trust is managing the trust by yourself or maybe a trusted people, and it is for the benefit of the few members of the family, or maybe yourself is there, or you have some charity objective or whatever. So that is particularly a gift given from your wealth to a entity which is a trust. Trust is also private trust, so you have your own rules. You can manage yourself, but that is something you are already gifted. So that gift becomes for the benefit of those people to whom you are given, and you can manage it, but you can't take it back or something, right? So
you mentioned, writing a will for Indian assets as well as for US assets, what can be done. What does the process for a trust look like? Like you mentioned that who should make a trust. So trust can be made by anyone having some special conditions, some NRIs, so those with specific use cases for their kids, right? That they want to make a trust, which cannot be challenged, etc., or matrimonial disputes, business creditors. What does the process look like? Is it very complicated? Can me or someone else make it?
Good question. So the word trust is new for quite a few people in India. Like a will is almost at a negligible level. Trust is upcoming now. Trust is more safer thing that I've explained to you. But the process also is quite simple, not like a will. The will you can make in a couple of days. Trust is something where you need the help of a legal professional, where they will guide you to write the trust deed, which is 3-5 pages of document, which is rules, how you want to give it to the trust, how will manage, how the trustee can behave, and how the benefit can be given to beneficiaries from income, from the corpus, how many years it will live. So the drafting of the trust deed is something where it takes about 1 week time, and thereafter one is to register with the local sub-registrar office if possible, for making it a very legal trust. People are doing trust with the notarization also. So that is also absolutely fine. If you are transferring movable asset like cash or a demat account or something. Movable asset are fine without registration also. So the process may be 2 weeks time, which takes the time more on discussion of your thoughts of how the trust will be managed. Trust can be managed by yourself also as an option. You can manage till your life, and thereafter that can be managed by somebody else from the family or any of the relative or professionals, so that that continuously manage the trust and give the income or the fruits to the family. And at certain period, you mentioned 10 years, 30 years, 90 years, everything will be then dissolved and it will be distributed to the family. So in a will, you are giving immediately. In a trust, you are giving after a few years. It's a deferred gift, okay, inheritance. So it's not difficult. It is also we are making quite a few trusts every week in India.
So, if I'm making a trust, what does my role be in the trust? Who am I to the trust? And if I want to give it to, let's say, my kids, who are they to the trust?
So in a trust, typically in a will, you can write whom to give. So you are the testator and they are the beneficiary. The will, there are only two people: the testator who is writing a will, and to whom you are giving are the beneficiaries. There could be one middle person who is the executor who will manage the distribution. So in the will, they are likely the testator, the executor, and the beneficiary. Similarly, in a will, the person who is creating a trust is a settler. The person who is managing it and distributing the income and thing are called trustees. The beneficiaries are to whom they are benefit are given. So more or less similar situation is there in both the document. The arrangement is similar. In a will, everything is given as soon as somebody dies. And in a trust, it is given in the manner and in the timeline what you mentioned in the trust deed. So many people they write trust for the grandkids. So they say my kids and my grandkids should get benefit, and when my grandkid become 30 years of age or 35 years of age, I will give everything to them. So that is the timeline some people they mention.
Is there some particular net worth that is associated with trusts, or it's just all the use cases that you mentioned?
So one is net worth is criteria is there where one can really because typically I think people with one flat or very good family and all they may just continue to will, but people with say 25 crores wealth and they feel that if something stuck up, everything will be stuck up. So normally people with those type of wealth also should consider that they are taking a risk if they are not doing it proper estate planning by creating a will, trust, and power of attorney. And this is something which is the wealth size. Otherwise, the other purposes are, as you mentioned, that somebody has matrimonial issues, somebody has a special child, somebody is NRI. So those are the objectives, purpose are there. But the wealth size, yes, I understand that depending on the people's each profile of the family, they can decide. The wealth size is something which one can really keep in mind. We have recently done one trust for NRI parents who got a citizenship along with the kids. They only had a 5 crore of demat shares, and they still created a trust and keep it, and they went away so that the money remains in India. It is managed well. The returns are good, and they don't have to declare in the USA because of this trust and also. So these complex scenarios are there where even the 5 crore type of wealth also people are creating a trust.
Mr. Jatin, what is the one document besides the will that everyone should have, but many overlook? We know the will is very important for succession, etc. What's the other document that one should have?
So no, normally trust and power of attorneys are also important, which applicable wise. The power of attorney is something why we are saying that. See, if person is died, thereafter the asset is distributed. But there are so many cases that we see that people got bedridden or they are unwell and their asset they can't use it. So what happens to those type of scenarios? Have you given powers to your family member so that even if you are in incapacity mode, someone can use the asset for yourself or the family? Power of attorney is also one of the document people should have it. Reciprocal, you can give each spouse to each one, or parents are given to kids, so that at least in the course of the unwellness scenario, the bank account, demat account can be operated for your safety or for your life care.
Got
We
it.
have cases in past where during the COVID, one of the elder person was in hospital, and the family didn't had anything to do. The spouse was a joint holder. He also got admitted, and they both unfortunately got died after 20 days, and the hospital bill was more than 20 lakhs. And the son came to us that please help us. Then we had to move to the court for the guardianship order because there was no other name was mentioned in nomination or anything, and that is where the difficulty is. So a power of attorney is one of the document one can see. Also, the people are making a will or a trust of power of attorney. It is one of the legal document, but people are not telling the family about other personal things like where are my locker keys, where are my insurance policy kept, where are my property titles are said, who are my tax advisor, who are my wealth advisor, who are my insurance agent, because all these people and all these things will help when they are going for a transmission of the asset. If you don't know, like a bank relationship manager or wealth advisor like Amitabh and Fission Wealth, so people should know pass on, because the next generation doesn't know what we are doing, or they are not interested, or they are in their life. So suddenly those type of situations arises. One should keep a document which is giving more detail. We give always along with the will my wealth book to the family, so that they can give the prompt to the family along with the will, which is not a legal document,
Yeah.
but it is a guidance or tips.
Got it. If you had to explain succession planning in 3 words, so how would you describe it in 3 words?
Pardon me, can you just repeat question?
Would you explain, if you had to describe succession planning in 3 words, which 3 words would you use to describe it?
This is something which we can say that it's completing your life cycle journey. Okay, so it's a completion of it's achieving the last goal also, because this is the last leg of your complete family, because it is you've been doing your career path, you're going earning a wealth, you are saving a wealth, you are multiplying the wealth, but this last leg is something missing. So we would say that attend to the last leg. It is something which is people are missing, and that is a confusion to everybody. You're mute, Jugal?
Yeah, I was saying, what is the most unusual request that you received for a will from a client? Anything unusual?
Yeah, I think many a time it happens that people are at a very difficult time they approach us, and sometimes it could be at a deathbed, sometimes it could be when they're flying off to some countries for a vacation, and suddenly they say that I want to do a will. So we then say that, okay, we have online will process. You can sit at airport or at home. You can make your will quickly at any hours of the time.
Any particular client that you remembered who had a very different wish or beneficiary details or something like that?
So yeah, we had a one young woman of 34 age. She came to us and she created a trust, and she said, "I'm not going to marry. I've got certain wealth, and I want to dedicate to my cats." So she had a one cat and one pet, I think dog, and she created trust for them, and after that to some of the family members. So that trust, that is something which I remember. It was, I think, about few years back that we did.
Wow. What's the one thing that you wish every client would already know before meeting you?
So at least they should know what is their thoughts for giving the wealth, because they expect that we have experience, you guide us. It is not possible. Your family or the client's family dynamics, they know who is good, who is bad, or whatever within the family. So that is something expectation they bring to us, and we have to give them various scenarios or options to prompt them. We can't help them whom to give. So that is something they are confused. And one of the biggest reason, they procrastinate that, okay, I'm still not decided, I'll come back. And so that is something one has to decide. No doubt, you can change your will every year, every 3 years, 5 years. But at least when you come to know very clearly that how you want to give your wealth.
Making their wills, is there any typical mistakes which you see people doing?
Yeah. So that's what I was just mentioning to Jugal, that people are writing a will and then they are mentioning lot many assets which is not completely owned by them. And they say, this is my investment I have done. Legally, it is not true. And that is why people are making mistake. Also, writing a will is something they should keep it very simple without any contradiction or vagueness. Sometimes people say, everything I will give, I want to give to my spouse. But in somewhere down the line, they say, I want to give my bank account or jewelry to my daughter and all. It's a contradiction. So sometimes people made mistake on understanding this thing. So that's how we want to tell that it should be kept very simple. Don't create a vagueness. Don't contradict yourself in the will. Because after you, the will document is someone has to read it and interpret it and use it to execute the property. If there is a vagueness, then there could be a misunderstanding and a fight between the family member, which is you you work for 40 years for keeping the family bonded, and by one mistake, the family will be debonded because of your mistakes of not writing a will or writing a will which is incorrect.
Right. Fair. So what we will do, we will quickly move to the questions and answers because there's quite a few of them. So therefore, this helps. In a lot of discussions, we have also noted that some of the complexities which one had thought of are actually not as complex, and you were explaining some of them in terms of that the effort which it takes upfront reduces so much of effort and pain downstream that it is unbelievable. And we have seen a few cases. One of the things which didn't get really fully discussed, or if it got, then I missed out, was around that. Now, suppose we are in a situation that we did not make a will, and the eventuality has happened. Now, how much time typically would it take then to resolve it? And we face this very often where someone's parents are no longer there, all the papers are not at one place, getting it I know that you also have a practice where you look at solving such cases, and it's in my mind it is both expensive, time consuming, painful, and so what is the longest which has taken to get somebody's money which belongs to them because will and some of these documents were not in place?
Right, Amitabh. So currently, as you mentioned, we are doing two type of thing: pre-death planning and helping the people for creating will, trust, or guiding them what to do estate planning. The second is we're helping the family where somebody's died, inheritance assistance. So inheritance assistance is something where we help them to understand the legalities of the asset they know. They don't know few of the asset is lying somewhere, and we try to grab it from the everywhere the treasure hunt type of thing, and then we help them to transmit it to them. It may take a year or 2 years because of from that we do code. So we have a team for books separately. They have team who are doing court matters in all the places around India, and we try to see that we efficiently and professionally help them to cut short the time of the transmission. So they are the two that we do. To answer your question, we have two cases which I can tell you. One of the case is well-known royal family case of Baroda, where the fight took 20 years for the family to settle, and then the value size was more than 20,000 crore way back in 2006. So that is the ultimately they settled and they distributed. So that is something I know. The recent one, something has come, which is the person died and doesn't living behind the nephews, so not married and all. 20 years has gone, and they are still figuring out within themselves that who to take, and they have applied for succession and those stuff. 20 years, the one generation already gone, second generation now playing around. The value size is say around 15 crore listed company share lying in IPF. So this is the time of the getting the wealth in a time properly and distributed as per the requirement of persons. The one question which I want to just answer, which within your question, there was a thing that why this becomes so important now. Not only COVID, if you see the dynamic change, money is becoming powerful than relation. So earlier, everything was managed by the family members. Everybody was respecting. Now, everyone in the family, they need their pie. So these dynamics of change and the tradition and the culture is changed.
Right. So one of the things which I would want to tell our audience as well, that we have in our partnership with Will Jini. So all these services which we have spoken about is available to all our clients. And of course, whatever is wherever it is relevant, customized, we will have separate discussions. But just from information, all these services in a simplified form. Now, moving to the questions, and I'm just going to go sequentially on the chat, and there are other questions which are there, which I will request Anurek and Ayushi to assist, because some of those questions have also come on the phone in the interim period. So one first question, I'm just going in sequentially, is what's the procedure to write a will? I think this question was answered in the initial part of the question. So really, and I'm just summarizing from my understanding 2 lines, and I'll giving him a 30-second break to put his thoughts for the rest of the more difficult. Use the help of lawyer. So there are various modes and modalities which are there. A standard will can be done online, or if you want a lawyer to sit across, draft something customized, it can be done. And all those scenarios are available. So it can be from very simple standard draft to a more complex customized. So and we can discuss in more detail in specifics as you're looking at your own will. A second question which is there, if an asset has a nominee or a joint holder, example, a mutual fund or a property, is a will still needed?
So what happens, say for example, I have a mutual fund or a demat account and I have put my wife as a nominee. Okay. Now, if I don't make a will, technically, as per Hindu succession rate, my wealth should go to my wife, my daughter, and my son, and my mother equally. Okay. So if I have not made a will, the spouse will take over the asset from the demat authority, but she will become the custodian or a trustee, and she has to distribute to these other legal heirs equally. So yes, nomination it's a short process which government has introduced, that money is given to the one of the family member, but it is not the right person. Maybe it could be one of the person who is managing it for others. So then the other legal heir has to demand it, take it with the properly, or they have to file a case. So that will and nomination is same.
Right. Fair enough. So the next one of the questions which came in, because you did talk about registering a will in the middle. So what exactly is registration of a will?
Or a close relative, but there could be a distant relative, friend, neighbors. This is a will which is legally in India, is will which is accepted everywhere in the court of law. You want to say that, okay, these two witnesses may or may not be available to prove when somebody challenges. So this issue comes when somebody challenges the document, that this is right or wrong, or this is a fraud. Then it is good to go to government agency like a registrar office, where you document register for the properties and all. You walk in and you give it to them. They will register it, and one copy will be remain with the government, and they will have a registered will on the stamp on the will. So that becomes a very authentic for the people when they read it. Like you go to the bank after somebody's demises, you give it a registered will. They will feel that it is registered. The person had walked into the government office, so there is no doubts on the will whether it was a fraud or it was a thing. So registration may help in a little more authenticity to some of the agencies, because everybody is not legally that no qualified.
Right. A very interesting question from Ketan. The question is that how does one account for alternate scenarios in a will? For example, the possibility of a spouse or a beneficiary pre-deceasing the testator.
Right. So in our will that we write to everybody, whether online or offline, we always ask them, say for example, alternate beneficiary, alternate executive, alternate guardian. Always we ask these questions. even further alternate also. So this is a typical good planning that you have to ask if somebody is predeceased, who this should go if you don't change the will. So you can have within the will itself. So it's always alternate thing you mention in the will itself.
Right. Another question is that can you make a will in favor of a person who is not a direct bloodline or spouse? I think the answer is yes, but let's hear from you yourself.
Yeah, absolutely. You can give to anybody. You can give it to any charity, any third person, anybody. Recently, we have got a case, interesting case, a female married woman. She has some relationship, and to the married male, she wanted to give everything to him. But during the lifetime, if they have this arrangement, then there is a taxation issue. So by giving via will, there is no taxation issue. So this happens. People are giving it to friends, relatives, to the charity, everything. It is possible.
Right. There's a question from Nitish, and I think you have covered it in some form, but if there's anything else to add on that, what is the difference between nominee, either or survivor, will beneficiary, and trust beneficiary?
So the trust beneficiaries, I will take it from the other side. The trust beneficiary is something where the asset is lying in the trust, and the beneficiary is taking the benefit of the income, or at the end when they distribute to terminate the trust. So that is the trust beneficiary. Will beneficiary is the ultimate beneficiary of a wealth. The either a survivor or the nomination are the regulatory laws, which is not for the succession matter. So, for example, if the banking law says either a survivor or a dematting, SEBI's loan or demat, those things are there for operation part. They are not actually a legal thing. So, even though it is mentioned either a survivor, the other person is using it, on the day of death, one is to ask that my 50% was there, please give me. So legally one can ask. RBI is regulator for bank, SEBI is regulator for the demat and mutual fund and all, IRDA is for insurance. So those regulators have their own law for operations, nomination and all these things. But it is no, but the succession law is above all, where you should know those are the operating things, and to ease out the government or those agencies a headache. But it is not the ultimate law.
Right. So, and just a small bit of my take on it in terms of obviously a nominee is important because nomination is mandatory also in mutual funds and things governed by SEBI, because it then at least there is somebody who's rather than the money remaining unclaimed. Either or survivor really is something which helps one determine as to who would operate the account. Just please remember that from a taxation perspective, in a joint, if the ownership is joint and both are signatory, then the tax liability would be typically on both. While you would have to consult a tax consultant for very specifics, but in either or survivor, then the first holder is whose ownership is primarily taken from a taxation perspective. Of course, from a succession perspective, a will or a trust, that's which is the ultimate beneficiary, because that's somewhere where the nominee is expected to transfer the funds to the ultimate beneficiary, and that's where it is more powerful than a nominee or some of those metrics. So I guess all
add
have a
on,
place.
sorry, Abhishek, Abhitav. So to add on, this nomination thing has been introduced by the government because every family member, when they had fight in the will, they were making the party bank or a demat people and all. So government said nothing doing, we are getting out. Then you fight within yourself. So that was something the government stand, that you give a nominee and we are out of the family dispute. Otherwise, lakhs of the cases going on where all the bank manager or the demat people will go and fight. So that is something is for them also.
There's a question from Neha on types of pets. I've seen that Jugal has responded to that. If there's anything else on that question, then Neha, you can ask and we will pick it up. What just for the benefit of everyone, said that in the case of where the are minor or pets or charitable causes, then making a trust makes more sense. And the question was in terms of how do you secure the future and lives of pets?
Because when you give it your wealth to the pets or minors, they can't manage legally, and that's how we want somebody, a manager. And that concept comes from the trust. That is the reason.
Okay. A question from Vivek to everybody or to us is that where does one store the will and how does it get revealed after the concerned person's demise? Keeping in mind that person might not want to reveal the contents of the will to his near and dear ones while
True.
he's or she's
Yeah.
alive is what I presume.
Correct. So what typically people are doing, whether they keep a will in their own safe deposit locker on the house or whatever. So, but if they feel there is a risk, they get hand over it to the friends or a relative or executor. Our company also has the services. So our company provides services for advisory, writing a will or trust. We become the executor of the will. We are also custodian of a will. We have a safe locker where we keep and we give a certificate to the people that somebody dies and bring it this certificate. We'll hand over the will to so and so person. We also help in the trust as a trustee for our services are also that we provide a annual legal manager concept where people can be no subscriber to a manager where any legal issues from the property side or any business side or any side, we can help them with some nominal.
So actually, in terms of wherever there's any customized requirement, the whole purpose of going is to be able to have information and knowledge which is available to the successors. So as say the right amount of information to the right person at the right time. And I think that there's something which is what all of these would help one achieve. There's a question from Mudit. Is living will having any scope and significance in India?
It was earlier not allowed. 2 years back they have started, where person is writing a will and they go to the magistrate level and say, though my health is not well and they are using life-saving equipment, please remove it after so many days. You appoint your doctor's panel. They will decide that I am brain dead, so my life-saving equipment should be removed. So that thing is now some of the people have did it, and the government keep become the part thing because of their own ethical and law issue. So this living will help for those type of cases.
Fair. So one of the questions which you had mentioned during your conversation that there is talk of inheritance tax, whether it might come in or not. So Pankaj Bhai has a question that this will become applicable soon. Do you advise to transfer assets now or mention the trust as beneficiary in your will?
Making a trust as a beneficiary in your will is a futuristic event. At that time, if the already inheritance tax introduced in India, then it will be applicable to that also. So if you want to plan, there are so many people who have planned, there are so many people who have created trust because of this threat or apprehension that there could be a inheritance tax might come to next year or maybe 5 years down the line. So tax in 85 they abolished. Now the time has come that again every time there is a discussion. So if you create a trust now and transfer some of the asset out of your 100 rupees, say 50 rupees you transfer. So that 50 rupees might not get into the inheritance tax issue. So some of the people have transferred 90% because they say this is big wealth. Even a 1% you take is going to be big money. So person with 100 crore wealth, even 1% tax comes, it's a 1 crore rupees. Creating a trust is hardly 3 lakhs type of cost or something like that. But to avoid that, why should we take a risk? So many people have taken that call actually.
Right. Fair. And also in terms of, I think where the government is currently, so with time will tell whether they're able to take, because introducing something like an inheritance tax is not an easy legislation to pass through. So it's something which will happen. I think we should look at it.
Which everybody knows that recently Lok Sabha election, Mr. Sham Pitroda and Mr. Rahul Gandhi told one of the event that US is taking 50% or 55% of the taxes on inheritance. Why not we should also introduce something like that? So that was a big discussion, debate and thing. So those type of thoughts are there in opposition parties. That is only one of the thing we can keep in mind.
Absolutely. So I think this is a topic on the agenda. And so I think as long as we are focused and clear on what we want and build it in, and it will be different for each individual as to how they wish to view it. And that's how it will take over. And we would be more than happy to have a customized discussion on that. One of the questions I can see a question on the pricing and again on from a pricing perspective, we have been Mr. Jatin Popat and Mr. Joel have been very kind to have a very, very preferential pricing for our clients. So we'll, again, based on what is the complexity, what is the opportunity, that's something which we could work on because it ranges a full range from online to having a lawyer visit your doorstep, to having a full trust, to having, as I said, storage of documents. So it's a very customized document. So it may be more appropriate to have a specific discussion on that than on a generic basis. But yes, it is fairly competitive in what they have been kind enough to offer. One of the questions which Ravi had, how may a joint property be added in the will? And Jugal has also responded to that. If there's anything further on that, then please, Ravi, please feel free and ask, and we'll raise that, which is common for.
So basically, I just for all the audience that we have been writing a lot of joint wills because we as a system that we try to make joint. So joint will is one of the things we are doing very regularly. Quite a few people are doing joint wills where each of the spouse, they can mention their single asset or joint asset in the will, and they want to say that everything goes to my spouse and later on to our kids in this situation. This is a standard way, and that is something very regularly we are doing.
Fair. And see, one of the question was, does the bank apply a debit freeze on learning of the death of an account holder? If there are joint holders, can they continue operating it? And how do executives operate the account while the probate is pending? So part one, I can answer. The answer is yes, because until and unless the ownership of the account is established, there would be a freeze on the account. It could be as simple as giving a death certificate if it's a joint holder, or it could be more complex in terms of getting the ultimate who's going to use the money before it gets unfrozen. How do executives operate the account while the probate is pending? Maybe if you would want to take it.
Yeah, so basically, if there is no dispute in the family, the joint holder can continue the operating the account. Later on, they can give the death certificate. They can give the name after the banking process. However, if there is a dispute within the joint holders, then the person who has died, his or her family will have to approach the court of law. They have to bring the necessary court order to freeze the account. Then only the bank will freeze it. Otherwise, as per the RBI and banking law, they will not stop this operation. The legal heir has to bring the court order to freeze it.
Right. In terms of, I have a question. If I'm part of a property owned by my joint family, can I will my daughter that property even though there is no clear owner currently?
I'm sorry, Amitabh, can you just repeat?
The question was that if I'm part of a property owned by my joint family, can I will my daughter that property even though there is no clear owner currently?
So there are two concepts. One is the joint property or one is the ancestral property. So ancestral properties are actually, there's a specific 4-generation law. Everybody, whenever they own, they are allowed to use. That concept is there. So ancestral property is difficult to give to somebody. But if you are a joint property because you got inheritance from the father and there are some properties are there not treated. So when I give you that, give it to my daughter or something, later on the can split into the ownership and give it to the individual. So that is how the scenario is.
Right. There's a question, does a foreign national with OCI, so Devesh has asked this question, does a foreign OCI having inheritance in India need to be India after it?
Yeah, it's good to write it all. And that is how the systems or the government agencies or the banks accept it, the process. Otherwise, the person who has not drawn a will, they will have to go to the court of law and bring a succession certificate or legal heirship certificate to prove who are the legal heirs and how they would to distribute. So asset in India is must actually.
Right. Are there any more questions which are there? I'm just trying to look at. So that if there's any questions which have come to me, which we have not been able to ask here, we will separately reach out to you, get the response and feed it back to the respective folks who have asked. So clearly, one of the questions which I had thought of asking upfront, which I missed out, I guess a large part of it got addressed through the Q&A, was why Will Jini? And I guess each of these questions have already demonstrated. So that question has become redundant in some form, because clearly this is an area which is very important. This is an area where they have tied up and have been servicing for many years marquee institutions such as HDFC, ICICI, and many others have been using their services. And it is something which we feel that they are able to bring in a lot of expertise, both domestic and international, in terms of being able to offer. They have offices not only in Mumbai, they have offices in a few cities in India. They have ability or capability to manage assets across many cities in India. They also, in terms of from an international assets, they are able to bring in some knowledge. So therefore, when we look at it for several of our needs or our clients' needs, we found that there is a very good mix and partnership which we can work on. Of course, eventually, this is not a subject which is, what should I say, generic. It is always customized. It is always individual, always has nuances. And that's something which we are cognizant of as we do wealth management as well. It's an area where we would be more than happy, Anulekha, myself, Ayushi, Ritika, to take forward any discussion which you may have and use those discussions and take them in a more distilled form to them so that we are able to do that. Again, this discussion is extremely confidential. While some of the generic discussions which could have happened here, these discussions have to be held in utmost trust. We understand that, and that's something again which is something which we work with. In fact, some of the discussions, if you choose to have with the Will Jini team, even we would not be aware of it, because it's not necessary for us to be aware of every single detail which is there. It's your choice whether we would need to be aware of it or not need to be aware of it. So confidentiality is something which is at the heart of this business or this aspect, and that's something which again, in our assessment and discussion with Will Jini, we are absolutely confident of that part or that aspect of discussion. So what I would do, I would, if there are no questions, thanks a lot, Jatinji, for taking the time out. My apologies once again for a very distorted start. There is some things, as we said, like Wales, which is not in our control. The internet conking off last minute, just as we were about to start, and we were trying to figure out how to do an alternate part and part.
One question you missed to ask, when I should write a will. So that goes to uncertainty which we face today, because none of us we don't know date of expiry. Okay, like all the FMCG products you see date of expiry. We are the only product in the world that we don't have a date of expiry. We don't know actually. We have a date of expiry, but we don't know. And that is where the whole estate planning comes into play. Even at the age of 40, we are hearing people have gone through a difficult time. People with the various celebrities has been facing those issues, and sometimes because of stress and issues, ailment and all. So this is something, uncertainty is always hovering around in all the places to all of us.
Absolutely agree. And on that note, we are very glad that we could have this discussion. This was a very something which we are hoping that if there are any further queries, questions, or anything which we can assist in, we would come back as a partners to address that. Thanks a lot, and have a good weekend.
Thank you thank you so much, Jugal, for taking in as well, for picking up.
Wishing you all a great festive season ahead. Thank you so much for your time today. Thank you so much.
Thanks a lot, and thanks, Jugal. Special thanks to Jugal for substituting for us in the middle.
Anytime, sir. Anytime.
Thank you.